Well, I am live. Guys, thank you for joining me. My name is Lior Samfiru. I am the employment lawyer. I'm one of the founding partners of Samfiru Tumarkin LLP. We are the largest employment law firm in this great country of ours, Canada. So why are you here? Why am I here? Well, we're both here to talk about employment law. We're both here to inform you and educate you about this very important topic, to give me an opportunity to answer the questions that you may have always had about employment law, about your job, about your rights, about whether your boss is doing something legally or illegally. So if you're dealing with a question about employment law, if your workplace is not the best place right now for whatever reason, you have that opportunity to ask questions right now and to make things better, to inform yourself. It's so important to inform yourself when it comes to employment law. Maybe it's a situation where you've lost your job and you want to know, is that legal? Do I think it's a wrongful dismissal? Did the company have a good reason or a bad reason? What about my severance? Well, ask right now, I'll tell you. Maybe it's a situation where your job has changed, your compensation, your hours of work, your responsibilities. Can that happen? What are your rights? What to do about that? Well, ask right now, I'll tell you. Maybe it's a temporary layoff situation, a workplace harassment situation. Maybe it's an overtime issue. If it has to do with your job and your workplace rights, you're in the right place. You have the opportunity to ask questions right now, and I encourage you to do that. I have plenty of stuff I can talk about, and I will talk about today, but I'd much rather be answering your questions. Now, before we get started today, I want to give you some other contact information if you want to learn more about your employment law rights. If you want to connect with me and my team to have a private discussion or private email exchange, here's what you do. You just go to employmentlawyer.ca and employmentlawyer.ca. And when you go there, you'll have all the information you need. You can read about employment law and find out more. And of course, connect with me. Phone numbers there, email address. Again, employmentlawyer.ca. That's the resource you have for employment law. But that's for later. Right now, I'm live right now on this platform, whether you're on LinkedIn, on Facebook, on YouTube, wherever you're watching me right now. Ask, you have a box there, type in your question, press enter. I'll see it, I'll read it, I'll answer it. And I encourage you to do that right now so that your question can get answered. Sometimes I get questions right at the end of the segment, and then I don't have time to answer them. So again, those joining us, I'm Lior Samfiru, employment lawyer, one of the partners and founding partners of Samfiru Tumarkin LLP, live right now here at your service. I'm going to start answering some questions right now. And first question today comes to us from Pete. Pete says, I've been employed for just over 2 years and I'm on a work visa. My employer let me go due to work shortage. Am I owed any severance in the situation, even though I'm on a visa? So the answer is yes, absolutely yes. If you're working legally here, whether it's on a visa or for any other situation, if you're working legally, that means you have the rights and the entitlements of every other employee. The law doesn't distinguish. As long as you're working legally, you have rights. So if you lost your job, you're absolutely owed severance. Now, what I don't know, Pete, is I don't know the type of job that you were doing. I don't know your age. I just know that you were working for 2 years. But you'd probably be looking at anywhere from 3 to 6 months of severance. Could even be more depending on your age and specific job that you were doing. Very important to remember, even after 2 years, 2 years is not a long time necessarily to be working. But even after 2 years, the amount of severance is going to be measured in months, not days, not weeks, months. And it could easily be 4, 5, 6 months, even more than that, even much more than that, frankly. So that's why you have to always make that call and ask questions about your workplace, right? So yeah, if you're on a work visa, if you lost your job, you're going to be owed the same severance as a regular employee that's not on a visa. Absolutely. And that severance, again, could be significant. In fact, it could be as much as 24 months of severance. You see how easy it is to ask questions and get answers with respect to your workplace rights? You can do that as well. It takes a few seconds. Be that second voice on this segment here. Ask me the question. Give me that opportunity to answer your questions. Now, in between those questions, I wanted to talk about when you should be calling my office. So people often say, well, okay, something's going on in the workplace, but I don't know if it makes sense to call Lior or to call a lawyer at all. So I want to talk about situations where if this happens to you, I don't care. You pick up the phone and you call, always. Okay, so the first situation I'll talk about, we just addressed this right now. It's if you lost your job. Now, I don't care if you work for 2 months or 20 years. I don't care if you're young or old. I don't care if it's a senior position or a junior position. All right. If you lost your job, you have to get legal advice. Okay, always. The reason for that is in almost every situation when an employee loses their job, they have legal rights. They're owed a lot more than what their company is offering them in almost every situation, well over 90%. So whether you work for 2 months or many, many, many years, chances are whatever you've been offered is a lot less than what you're owed. And you need to call me so we can discuss that. In some situations, the termination itself may be illegal, and we need to discuss that as well. I spoke the other day with someone who was let go a couple of weeks after she filed a harassment complaint. Can't do that. That's illegal. So there's a lot to discuss, and you have to stand up for your rights. What you don't want to do if you lose your job is to sign off on that severance offer, even though there's a deadline, even though you feel that pressure. Do not, under any circumstances, sign that. Okay, do not. Once you sign it and you realize, oh my God, I was owed another $75,000, you can't do anything about that at that point. Okay, so that's number one situation where you have to contact my office as if you lost your job, and you can do that, of course, through employmentlawyer.ca. Again, employmentlawyer.ca. A few questions have come in. I'm going to answer them. Ask your question. I'm live here, Lior Samfiru, the employment lawyer. I'm live, so let me start answering some more questions. Next question comes to us from Randolph on YouTube. My company is moving to a new location. How far away would it have to be considered to be a change to my employment? So it's not how far away. The distance is not relevant. It's how it impacts you. It's the time that it's going to take you to get to the new location. So here's a good rule of thumb. If the new location is going to take you more than an hour more than you used to before to get there or to get back, well, that would rise to the level of a constructive dismissal. In other words, if your employer is now moving and it's going to take you an extra hour to get to work more than it did before, you may be in a position to say no. By changing the terms of my employment, in this case, the work location, that's a constructive dismissal. I can consider my employment as being terminated and make you, employer, pay me my full severance. Okay? Now, it's not about the number of kilometers, whether it's 2 kilometers or 2,000 kilometers, forget about that. It's how it impacts you. Because every person may be impacted differently, depending on where you live, depending on whether you have a car or don't have a car. So if an hour, that's kind of the threshold there. If in your situation, Randolph, the move is going to impact you by more than an hour, you got to give me a call because you have only a short window to deal with that. So you need to contact me as soon as possible. And again, to do that, easy, employmentlawyer.ca, employmentlawyer.ca. All right, continuing to answer questions, guys. Bring them on. Love these questions. That was a terrific question. Bring your question as well. Next question from Alon on YouTube. My employer accused me of harassment based on lies told by my coworker. It's been causing me a lot of stress, and I made a mistake on my last shift. As a result, they fired me right away for it. Am I still owed severance since I was let go for making a mistake? Absolutely. Yes, 1,000%. The thing is this, to be able to be let go without severance, you would have had to do something terrible, something awful, stole, hit somebody, fraud, sexual harassment. If you do that, then yeah, maybe you can be let go without severance. But you made a mistake? No, that's not enough to be let go without severance. That doesn't mean you cannot be let go. You can be let go, but your employer is going to have to pay you your full severance. And alone, depending on how long you've worked there, that could be 2 years' pay. Absolutely that it could. So very important to remember the distinction between doing something wrong. Yeah, you may have done something wrong, but between that and being let go for cause, i.e. without severance, those are very different things. The fact that you did something wrong, maybe even you did a few things wrong, does not mean you can be let go without severance. It is very difficult to let someone go without severance. It's really something that only in the worst situations can happen, when the employee did something so bad that it's just not possible to employ them anymore. Okay, so very important question. Thank you for that, Alon. And if in your situation you are owed severance, you gotta give me a call ASAP. Okay, employmentlawyer.ca to have all that contact information. Thank you for that. And again, see how easy it is. Those joining us, my name is Lior Samfiru. I am the employment lawyer. And why am I here? I think it's obvious by now. I'm here live answering your questions about workplace rights, about employment law, making sure that you know what to do if you're facing a workplace problem. All right, let's see. Next question from JX2 on YouTube. Working on call, was handed a contract to sign, which I did not. Am I bound by any contract by accepting work? If they sever the employment, how much severance am I owed? I'm in BC. So no, if you sign an employment agreement, then you're bound by the terms. If you did not, then you're not bound by it. So how much severance you're owed? Well, it depends how long you've worked there, your age, and your position. You're absolutely going to be owed severance, and it was probably a very smart thing not to sign that agreement, because that agreement could probably limit your future severance. So for JX2 and for everyone else, if you want to find out right this very moment how much severance you're owed, here's what you do. Very easy. You grab your smartphone, you grab your tablet, and you go to pocketemploymentlawyer.ca. I'm going to give that to you again, pocketemploymentlawyer.ca. You see that address on the screen right below me right now, pocketemploymentlawyer.ca. Why do you go there? Well, we have our severance calculator tool there. When you go there, you'll see the severance calculator. You can click on it, and then you can find out in seconds, about 30 seconds, how much severance you are owed. All right, it's completely free. It's completely anonymous. No one is asking you for your name or your company's name. It's just there for your benefit. No strings attached, no credit cards, nothing. Pocketemploymentlawyer.ca, and you'll find out, JX2 and anyone else, how much severance you're owed. Now, you can use that if you just lost your job and you want to know how much you're owed. Great time to do that. Or maybe you're worried that they're letting you go soon and you want to be prepared. You want to know in your mind how much severance you're owed. Or maybe you're just curious. Hey, what happens hypothetically if they let me go? How much severance would I be owed? Very easy. Just go to pocketemploymentlawyer.ca. Use the severance calculator. The very first place you go to if you lost your job. As simple as that. You'll be surprised, shocked maybe even, by just how much severance you are owed, because that's what the law provides. So check it out yourself. All right. Let's see. Just another Jack. What are your opinions on doorknobs? Well, that you're one. Next question from Sunny on Facebook. My employer fired me because I was injured on the job. It was during my probationary period. I don't feel this is fair. Am I entitled to any sort of severance? So let's be very clear. You cannot be let go because you're injured on the job. You cannot be let go because you're injured off the job. But it's actually worse if you're let go when you're injured on the job, because to let you go would be a violation of workers' compensation legislation. That can also be a violation of human rights legislation. So not only would you be entitled to severance, but there's potential additional damages you can be owed, and there could be penalties that the company may be subject to because they let you go in a situation when they're not allowed to let you go. So very important. You cannot be let go because you're injured on the job. Because of it, you cannot. And if you have even if we forget about the job itself, if you have a disability, an injury, a serious medical condition, you cannot be let go because of it. That would be a human rights violation. Okay, an employer can't punish you because you have a disability or because you're injured. Not only that, they have to provide accommodation. That may mean modified duties or modified hours, whatever your doctor says that you need. So if your employer says, not only am I not going to accommodate you, I'm going to punish you by letting you go. No, that's not legal. If that happens to you, in this case, Sunny, I want you to call me ASAP, today. Okay? That's how important it is. To do that, again, employmentlawyer.ca to connect with me. It's all right there. We need to get to work here, Sunny. Obviously, what your employer did, it was completely illegal. Okay, let's see. Great questions, guys. By the way, again, I'm Lior Samfiru, the employment lawyer, live here answering questions. I'm going to continue answering questions right now. A bunch of questions have come in. Don't wait. You have some time now to ask those questions. I will. If you ask them now, I will get to them before the end of the session. If you wait too much longer, I may not be able to get to them. So ask your question right now. All right, JX2 has a follow-up. I was also working on call with a different company. The position is no longer part of the company, was offered other work that is quite different. Is there a way trying it without losing severance entitlements? Yeah, all you have to do is send an email to the company and saying, I'm not sure how that job is going to work out for me. I'm not sure if I'm good with it, but here's what I'm willing to do. I'm going to try it for the next 2 weeks, 3 weeks, 4 weeks, and then I'm going to let you know how I feel about it. By doing that, you're trying it. You're not just going to be considered to have accepted it, but you have to put that in writing, and anywhere from 2 to 4 weeks, no longer than that. If it's longer, it's not going to work. And after that time, 2, 3, 4 weeks, if you feel good about it, fine. If not, it could be a constructive dismissal. Now, I'm not saying for sure it's a constructive dismissal, JX2, because I don't know what the job is. I don't know how different it is. So before you say to the company, yeah, that's a constructive dismissal, before you resign, we have to talk. Okay, I need to understand how they changed it. I need to understand the different responsibilities. Is there different hours? Is there different pay? So best advice, you have to give me a call. Again, employmentlawyer.ca. All right, Carrie, next question on YouTube. My employer has given us a non-compete to sign. I thought these were no longer legal. Am I bound by this if I sign it? Well, first of all, I'm not sure what province you're in. In Ontario, the government has implemented legislation that says that for many employees, it's not legal, but it's still legal for some people, more senior managers, etc. But even outside of Ontario, for most people, a non-compete is not enforceable. Our courts have said that unless you're a senior executive, someone in a very unique role, it's just not enforceable. Our courts don't like things that prevent people from working, that prevent people from earning a living. So chances are, Carrie, that legally that document is not enforceable. But that's not where it stops. So you may say, well, it's not enforceable anyway, so who cares? I'm just going to sign it. Well, no, not so fast. Here's why. Because if you sign it, it's not enforceable, fine. But what's stopping the company, your employer, from down the road trying to enforce it? What I mean by that is you leave, you work for a competitor, they sue you. Now, they will lose that lawsuit because, as I said, it's not enforceable. But in the meantime, they can make your life miserable. It could be difficult. It could be expensive. It could be very stressful. So you have to be very careful. It's never, ever a good idea to sign something thinking, it's not going to be enforceable anyway, so who cares? I'm going to sign it. No. If you sign it, you have to deal with the consequences of signing it. So my advice is don't sign it. Say, no, I'm not comfortable with this. I'm not going to sign it. So that's the best advice I'm going to give you. Always also happy to connect with you as well if you want me to take a look at it and give you my thoughts on the document specifically and about your specific situation. But best advice I'm going to be able to give on this session, never ever sign something just because you believe it's not enforceable. Even if you're right, it could be causing you problems later on. So JX2, you're telling me how long you've worked. So the best way to find out how much severance you're owed, again, the severance calculator, pocketemploymentlawyer.ca is the address of the severance calculator. Whether you work for a few months or a lot of years, it works just the same. It's going to tell you how much severance you're owed. And by the way, even after only a few months of employment, you're going to be owed a substantial amount of severance, okay? Very important. All right, continuing to answer questions. This one is for, I don't even know how to pronounce it. Magalese. Sorry if I mispronounce it. Magalese on YouTube. Currently on long-term disability. My own definition ends on December 2023. I'll explain that. Insurance company wants to change me to, I don't know what you're saying. Wants to change me. So you'll have to explain the question because it's cut off there, so I don't know exactly what you're asking. So next question is from John on Facebook. How do mandatory sick days work if you have more than one employer? Is it spread out across your job? I'm not sure what you mean by mandatory sick days. Sick days are not mandatory. No one says that you have to take sick days. So I'm not sure exactly what you mean by that. Magalese has another question. My back went out while I was at work. I didn't file through WSIB, just the company's outside insurance company. whose fault is this? And it is in my favor to report this. Yes, you should always report a workplace injury. Okay, always, because the law says you need to, and the law says, in fact, your company's aware of it. They should report it, so you should report it. I'm never going to tell you to do something illegal, ever. You absolutely should report it. It is in your interest to do that. There may be additional benefits or different benefits that are available through WSIB. If it's a workplace injury, you should absolutely report it, and report it ASAP. No question. All right. Next question from Ha on YouTube. I got laid off last week with the fake reason. Should I claim severance or should I try to file a wrongful dismissal case? Your calculator shows 6 months of severance. So wrongful dismissal and severance are the same thing. Okay, so what I mean by that is a wrongful dismissal is a situation when you're owed severance and you didn't get the severance that you're owed. That's what a wrongful dismissal is. So if you're owed 6 months severance and you didn't receive it, then you've been wrongfully dismissed. That's what a wrongful dismissal is. It's not different things. It's not separate things. Now, you say you got laid off last week. So if you were put on a temporary layoff, you can treat that as a termination and you can get severance, absolutely. If it's a permanent layoff, yes, you're owed severance. So if you're owed more than what you've been offered, you need to call me. Okay. In fact, you should call me either way. If the severance calculator shows you're owed 6 months, you may even be owed more. Obviously, I need to speak to you to understand that. And you absolutely should pursue it. If the law says you should have 6 months pay, then you should get 6 months pay. Not 1 month, not 2 months. It should be 6 months. So, I want you to call me as soon as possible. How do you do that? Just go to employmentlawyer.ca. You see that right over there, employmentlawyer.ca. My phone number is there. My email address is there. Forms are there if you want to fill out a form. So check it out for yourself and connect with me as soon as possible. So let's see. Next question is from Carrie on YouTube. I work for a software company, but I'm not a manager. Okay, Carrie was asking about a non-compete. I'm not a manager or senior employee. The non-compete would prevent me from finding a job I'm qualified for up to 1 year. So it wouldn't be enforceable. It wouldn't be. But remember what I said. The fact that it's not enforceable doesn't mean that the company is not going to try to enforce it. And why would they do that? Well, they do that because maybe they want to send a message to their other employees. Don't compete with us. They're trying to scare them off, and it could be doing that at your expense. So bottom line is, if they ever sue you because of it, you will win. Okay, you will win. There will be a victory for you. But if that victory takes a year or 2 years and costs you tens of thousands of dollars, is that something you really want to do? So my best advice is do not sign that non-compete. Just simply say no. If they let you go, they owe you full severance. It's probably better to be let go, but then you can work wherever you want. Because if you sign this non-compete and then they let you go, well, now you're in that non-compete problem where they could potentially take legal action against you. So very, very kind of important to remember that. Hopefully that answers the question, Carrie. If you want to connect with me, happy to talk to you and happy to give you more information. Again, employmentlawyer.ca. Have another 5 minutes here, guys. You can still ask some questions. I think I'm caught up with the question. One just came in right now, but still 5 minutes. You can still get a question in under the wire. So take advantage. I'm still here. Want to answer your questions. Next question is from Arthur on Facebook. My wife's job was eliminated while she was on parental leave. She was offered severance, but is this a human rights claim? Well, here's the thing. If the reason why she was let go has anything to do with the fact that she took a parental leave, not only is that a human rights issue, it's potentially an employment standards issue. It's completely illegal. If the position was eliminated, regardless of her parental leave, and there's nothing else available, they've tried, they've looked, there's just nothing. Yeah, they may be able to let her go just with severance. But I can tell you, I've been doing this for 20 years. It's rare for me to see a termination that happens during parental leave where it's really a legitimate legal termination. It's rare. So I'd want to speak to your wife, okay? I'd want to understand what her job was before, why was the position eliminated, how do we know that it was eliminated, what has the company done to try to find her another job? I want to understand all those things. But even if all of that still tells us that it was a legal termination, I doubt it. But let's say that it does. There's still the issue of severance. I can almost guarantee you that the severance that your wife was offered is less than what she's owed. Now, the fact that she's on a parental leave means she should be getting more severance. Why? Because she can't start looking for work right away, right? She can't because she's still on parental leave. So even more severance than she normally would have received is owed to her. So very important, Arthur, to have your wife call me or email me as soon as possible. Again, employmentlawyer.ca to do that, employmentlawyer.ca. Happy to chat with her. Happy to go over all these things to make sure that we help her. Again, employmentlawyer.ca. So that's very, very important for you to understand. Now, I've been talking about situations where you really need to call me, and we've gone through a bunch of examples here already today. Another one, of course, is that dreaded temporary layoff. So if you're put on a temporary layoff, remember, that's not something your employer is allowed to do. There's no right to put you on a temporary layoff, especially not that first time. So what I mean by that, if your employer puts you on a temporary layoff, you may be able to treat that as a termination and get your full severance. Now, if you don't do that, you don't call me, you just sit and wait, and eventually they call you back and you go back to work. Well, by doing that, you've given the company the right to do it again and again and again. So in the second, third, fourth time that they put you on a temporary layoff, you won't be able to do anything because you accepted that very first layoff. So anytime you're put on a temporary layoff, we need to have a chat. We need to understand the pros and cons of waiting and consider pursuing it as a termination, as a constructive dismissal. So if you're put on a temporary layoff, whether it's because of COVID-19 or whether it's because of the vaccine, or whether it's for any other reason, business reason, you got to call me right away. Again, employmentlawyer.ca. All right, last question for the day comes to us from Melinda on YouTube. My sister recently relocated to Nova Scotia but works remotely in Ontario. Is she still covered by Ontario laws? So if she lives in Nova Scotia and physically works in Nova Scotia, even though the company may be in Ontario, then it will be Nova Scotia laws that apply to her, not Ontario laws. So what matters is where you're physically located, not where the company is located. So if you're working from home, it's a question of where your home is. If your home is in Ontario, it's Ontario laws. If it's British Columbia or Nova Scotia, then it's those laws that apply to you. Now, the same thing happens if you're working, let's say, in Ontario and the company is based out of the US. I don't know, say they're based out of Boston. Well, it's not the laws of Massachusetts that apply to you, it's Ontario laws. And some American companies may not understand that and appreciate that. They may think that it's the laws of their jurisdiction that applies. No, it's the laws of where you work. And that's very good because in Canada, across Canada, we have much better employment laws than, let's say, they have in the United States. A lot better laws. So you want to have Canadian laws apply to you, not US laws. But for Melinda, for you, for your sister, it will be the laws of Nova Scotia that apply as long as that's where she actually is physically located. Guys, that's the time that we have for today. Glad that you could join me. Again, I'm Lior Samfiru, the employment lawyer. My colleague Sandy Chen will be back right here tomorrow, okay, at 4 p.m. Pacific, 1 p.m. Eastern, to take more of your questions about employment law. So join Sandy here tomorrow, 4 p.m. Eastern, 1 p.m. Pacific. And he'll talk to you about employment law. I'll be back next week here as well, but don't wait for me until then. If you want to connect with me, if you want to have more questions answered, if you want me to roll up my sleeves and get to work to actually help you, just go to employmentlawyer.ca. Do that now. Don't wait till next week. Guys, great questions today. As always, I enjoyed being here. I'll talk to you all again very soon. Thank you. Bye.